What are letters of administration? Letters of administration are letters you get when someone has passed away and they have not left a will behind, and they can enable you to manage the person's estate. And when someone has left a will, that's when you get letters of probate. However, in this video, we're going to focus on letters of administration. If you'd like me to do a video on letters of probate, kindly leave a request in the comment section. I'll be happy to present a video on that. So, what's the first step to get letters of administration? Before we even get into the steps, what are letters of administration? Letters of administration, simply, they are legal documents, or it's a legal document granted to the administrator that simply means that the family chose you or entrusted you to manage the estate of the deceased on behalf of the beneficiaries, and also to distribute the estate between the beneficiaries. The very first step to get letters of administration is getting a death certificate. How do you get a death certificate? Is you have to get a death notification that you can take to NIRA. So if someone died from the hospital, you get a death notification that you can take to NIRA so that you can be granted a death certificate. But however, if you find yourself in a situation whereby someone passed away from home, you have to get an LC letter. This is the letter that you take to NIRA to obtain a death certificate. Now, what happens when someone passed away years ago? What happens when someone passed away years ago? The process is a bit different, but however, it's not complicated. So the second step that you have to take is fill in a form. You have to go to the Administrator General's office to fill in a form. Usually this form asks you the deceased name, the children's name, the wife's name if they were married, the list of the properties that the deceased owned, and the value of the properties. After that, you have to hire a lawyer who can start the official process by opening up a file at the Administrator General's office. After the lawyer opening up a file, he's supposed to reach out to the COW of the locality so that the COW can order a family meeting so that they can elect an administrator. During these meetings, you can elect more than one administrator if you please. You can elect one or two or more than two administrators, or you can elect one, depending on who you trust to handle the estate of the deceased. After electing an administrator, these minutes are taken back to the Administrator General's office. The Administrator General goes ahead to review the minutes and issue you a certificate of no objection. After they have issued you a certificate of no objection, the lawyer takes the file and the certificate of no objection to the High Court. Upon taking the following documents to the High Court issues a notice in a widely spread newspaper, that is New Vision Daily Monitor. This runs for a period of about 14 days. If there is no objection during the notice period from the public, the administrator is called in to be questioned on a few questions. However, if it so happens that there is an objection from the public during the period notice, the court reviews the reasons as to why this objection came up, and there might be need to carry out another family meeting to elect another administrator. After that, if you're granted letters of administration, you have a right to deal with the land in whichever way that you want. Meaning the administrator has a right to transfer the names of the beneficiaries onto the title. And it is very important to note that you being an administrator of the deceased estate doesn't mean that you own the property. It means that you're entrusted by the family to simply manage the property on behalf of the beneficiaries and on behalf of the deceased. If you like this kind of content, kindly hit the notification bell and subscribe, like, share, and subscribe so that you can get more of this content more often. Until next time, bye.